Sam Shihab with the law firm of Shihab Burke, and with me,
Brian Burke from that very same law firm, sir. Good Monday evening to you, Sam.
update on the immigration talk with the White House. We have some updates for you. And then we're going to talk about the five most common questions in employment based green card applications. And we're going to tell you what those questions are up front. And then we're going to dive back and spend a couple minutes on what's going on with Congress and the White House and
Yeah,
what we know so far on the bill.
yeah,
So, Brian, the first one is, when is it a good time to change my job?
yeah. Next one is how can I make the process go faster? Yeah,
Priority date. Number three, priority date is current for me. Shall I do a tub or a second I-485?
num
Obviously, priority date is current on the other category.
yeah. Number four is hey, how can I get back on H-1B?
Number five, my medical has expired. Do I submit now or wait?
Yeah. So
But
we're gonna
before we
yeah.
dive into these, Brian, uh, give us a quick update on this discussion with the White House on the border security bill, and is there any love being given to employment immigration in it?
Well, nobody knows except for the people who are drafting it is the high level, but we have some sort of tidbits and updates, things that we've seen. For those who aren't aware, there is a sort of intense negotiation going on between Congress and in Congress and with the White House being involved in too for a reform relating to the border, relating to how asylees come to the United States and how they're processed. And there's been talk that maybe there's some other employment stuff, like maybe changes to the counting of employment-based green cards in there. We were hearing some talk about that early on. What we have maybe is a little bit more detail about what is actually in there. Well, about the asylum bits, and what we haven't heard, frankly, Sam, is anything that would really truly indicate that there's employment-based related reform. There have been some sort of leaks out there regarding what's what the contents are, and they really the big leak that I take to be taken with a grain of salt is that essentially it focuses entirely on asylum and basically the president's power to and requirement to shut down border acceptances of asylees when the when the encounters reach a certain point, essentially. Um,
And there's
and
some official statements made
mhm.
by some congressmen very much involved in the negotiations, telling us what is the bill not about, what
Yeah.
the bill isn't about.
So if I had to
Yeah.
have something that was makes me say thumbs down on anything that our audience might be interested in, it's these couple quotes from Kirsten Sinema, the senator from Arizona, who is apparently involved one of the drafters of this thing. And this is a quote from an article apparently relating to an interview with her that happened very recently. I think it may have been today. And here's what she is quoted as saying: "This is a border security package that seeks to create security and order on the border and to ensure that cartels are no longer able to exploit our asylum system," she said. "It does not address immigration policy for dreamers or farm workers or many other populations that are very important to Arizona's economy." And when I hear that last bit, any other or many other populations that are important to Arizona's economy, it sort of gives me the idea that there is really truly this has been really truly narrowed down to um, issues of security at the border, essentially.
Well, I mean, Arizona's economy is issues related to because they are a border state.
Yeah,
So a lot of things regarding the Arizona economy often deals with the undocumented.
sure.
So it may very well be tailored to that, but I have to agree with you ultimately, as I'm trying to read or labor to find positive, labor to read it the other way, and I am
Yeah,
not able to, because clearly any legalization or any relief for professionals will help the Arizona economy as well as any economy in the U.S. So, yeah, I'm starting to feel that this is not going to be something that is going to help us, unfortunately. And here we go again. Now there is a spin that
Yeah.
we can take on it that's positive. But Brian, go ahead.
Well, no, I was, no, go ahead with your spin, Sam, because I think that's
The
about where
only
I was
the
going
only
at this
the
point.
only thing, I mean, we've talked about this before we got on the air. It has to do with the fact that when you take the border security off the table, the employment immigration can no longer be held hostage to
Yeah.
it in the
Yeah.
future. So
Yeah.
it's always been people saying, I'm not doing this because you need to do this for me.
Yeah.
But obviously, there remains to be a lot of other issues that can be held hostage in the future. Um, that, but at least
Yeah.
taking the border security off the table clears the way for the other stuff to be next in line, hopefully with the next
Well, I'll
opportunity.
an alternate take of one of the other things we were talking about before we went live here. So again, we're just sort of picking up news crowns because there's no, as of a couple minutes ago, that seems there's still no text that is out there for the public to look at, and we're sort of going upon interviews with people involved and leaks and things like that. But a consistent sort of trend in the immigration conversation we have regarding legal employment based immigration, well, this is me trying to find my silver lining, is it's never the top headline. It is never the top thing that anybody talks about in um, in immigration. And there's always a chance in my mind that that can be slipped in there because it is inoffensive and agreeable to anybody, to everybody, perhaps. I don't know.
Yeah. And obviously, even this bill that we haven't seen, proposed bill,
Yeah,
it's not even a bill,
yeah.
proposed bill
It's a question mark.
that we haven't seen, even that one is at risk because there is a lot of momentum to even derail that because they don't want to give the Democrats a victory
Yeah,
in an election year,
yeah.
which is
Yeah, the
sad.
fun. It's obviously very much a right wing talking point that we want to do something about the border, and well, congratulations, you have a deal on the border. And the question now is, do we really want this deal on the border, or do we really want to give, do we really want to give the president that win? Essentially, do
Yes.
we really want to eliminate what our linchpin? We have a major election coming up in the fall of 2024, sort of issue.
Yeah.
Yeah.
So, Brian, what is the first most common question in employment based green card application that you are going to talk to us about?
Yeah. Well, the it's a good first one. It's, hey, when is a good time to change jobs?
How much time you got, Brian?
Well, okay, so I guess that means, well, Brian, it's kind of a fact sensitive question, right? It's kind
Yeah.
of depends upon the individual's circumstances. Well, maybe just some general. We'll talk about some general sort of things to think about here,
Hmm.
right? Number
Hmm.
one is PERM processing times are incredibly slow. Just the processing time of the labor certification, the PERM labor certification with the Department of Labor right now. I'm not quite sure if the standard times have fully gotten up to 1 year, and this is when I'm going to go check my inbox and see if whether they really are at that point. But the bottom line is they're about a year, and meaning that doesn't even account for the fact that a prevailing wage has to be obtained, a recruitment placed, put together a proper filing in the end, things that also take time. So basically, as a practical matter, if your priority date is coming up, you know uh, don't count on changing to that new job, new perm, because your odds are you're considering it takes about really 2 years to get, a year and a quarter, 3/4 to 2 years to get a labor certification in hand. If you're starting from scratch, it's not something that's going to be lickety split, is the bottom line.
And obviously, the slowness of the perm is slowing everything. People not wanting to change job. I mean, it's
Yeah,
basically holding people up.
yeah.
So, how can I make the process go faster, Brian? Can you really make the process go faster?
Well, uh, again, about 5 different answers depending upon where you are in the process. So, a lot of the conversations we're having lately is people are calling us saying, "Hey, my priority date has just become current. June of 2012 in EB3. What can I do to make sure that my case is ready to go?" Um, and the answer for me is, is make sure that your case is in order. by the time when your priority date becomes current. So we're talking to people right about now about, well, if you want to send a transfer underlying basis request, are you going to send in a medical exams to head off that medical RFE? Things like that. Really,
Priority date is current again.
yeah,
Um, do I file a transfer underlying basis? I think the better question is, when do I file a transfer of underlying basis, and when do I file an I-480, a new or second I-485? A new I-485, Brian, is taking a year and a half approximately to process.
yeah.
A transfer of underlying basis gets that adjustment of status in front of USCIS a lot quicker, right?
In theory,
Uh,
yes.
in theory, well, it's clearly better than a new I-485 under
I
the circumstances.
I will combat you on this, Sam. I will play
Yeah,
the devil's advocate at you.
sure.
Travel back about I don't know, about maybe a year and a half ago,
Hmm.
sometime in 2022, when people were asking the same question. There are people who filed a second adjustment of status and they got them approved in like 2-3 months
Right,
because the work had been done on the other case essentially.
right.
So I well okay, so there's two.
So that example is, you cannot prove the rule by proving the exception.
Yeah.
That is not the rule.
I
Uh,
agree.
yeah.
It's very possible that if you file a second I-45, you're stuck in the 12 to 16 months for us to process that case queue.
And it's really, ultimately, there is no way you can tell me tub is better than 485 or 485 is better than tub without knowing the specifics of the person, the case, the job conditions, the working conditions, the
Yeah,
circumstances. There's so much that goes into advising a client into which is really better
yeah,
for you. I mean, you and I spend so much time on the phone with consultations
yeah,
for clients. Say, I really want to consult with you on my situation.
yeah,
And you get on the phone and you spend 20 minutes building up the person's background. And then all of a sudden, you start, as an attorney, we start seeing a path,
yeah,
and we will, typically say, okay, that's the path for you. But there's no way I can say, well, tub is better or 485 is better.
yeah. I
Uh,
mean, I'll give you another scenario, or a scenario where I think the second 485 is better. It's ooh, we think one of your I-485s is. We think your status in the United States is dubious. We think that one of your I-485s has an issue. It's called give them a second one out there means a potential second means to stay in the United States if your other one is denied. You know.
and you are going to sit down and you're going to get into forums, and there are a lot of these forums on the internet has great information,
Hmm.
uh, and a lot of it has garbage.
Yeah.
Now I can get on a forum and read it and say, wow, smart. Oh, stupid. Oh, great piece of information.
Yeah.
Dumb piece of information. Why can I do that? Because I'm a lawyer. I've
Yeah.
been doing this for a long time. You cannot do that. You are going to get the bad with the good, and good luck figuring out which is which.
Yeah.
Consult with an attorney on that one, tub or 485.
Yeah.
But the next one, Brian, is how can I get back to H1B? I am now on EAD, and now I would like to get back on H1B because of a certain personal circumstance, whatever it may be.
Yeah.
How can I get back to H1B?
Well, so there's one sort of scenario, the government policy, literally from 20 years ago. Sam, I lost a bet to you on how old this was, but it's literally, I think it's from the year 2000, basically saying, hey, if you're on valid H-1B status in the United States and you have a pending adjustment of status, and you leave the United States while you're on H-1B status and come back using your advanced parole, we'll allow you to, when it comes time to extend your H-1B status, when your H-1B is about to expire, we'll allow you to resume your H-1B status by filing a new H-1B petition. Essentially, they will honor your H-1B work authorization and sort of, even though you entered on advanced parole, consider you to have allow you to get back on H-1B status, even though technically you aren't in status at the time you file that H-1B.
Mhm.
Now, people ask us a lot of different variations upon this. Well, Brian, what if I started just using what if I let my H-1B lapse can I, and then I travel and come back, and now I'm here as a parolee. Can I do it? And the answer is, per that policy, it's not the answer. It doesn't say you can. As a practical matter, though, I think somebody could make one of those H-1B filings and basically explain the situation to USCIS, and in theory, they might be willing to put you back into status. I don't think you can. Do you think you could count on that, Sam? Because USCIS will sometimes approve things that essentially
Well, you
wrongly, though.
you can count on it. You can count on it today. You may not count on it 18 months from now.
Yeah.
The answer, the the gray in the business of immigration law is probably 40% of
Yeah.
the spectrum.
Yeah.
And the black and white is about 30-30.
Yeah.
Okay. So today we live in a world in which the gray is very light gray or close to white, meaning that the government is leaning for approving things and facilitating processes. You don't have to go back too far in history, and you may not have to go back too far in the future to find out that that is going to flip.
Yeah.
And what is approvable today may be absolutely not approvable a year and a half from now. And I go back again to beat on an old story of mine is the EB1 application. I have seen enough in immigration law to tell you that good times are here, folks, for EB1
Yeah.
in 2024. I cannot say for sure what's going to happen in 2025. And we've been talking to a lot of people. I spend a lot of time, and Brian, you spend a lot of time talking to people,
Yeah.
going through the EB1 process. Very smart people, and approvability is easy, just like your advanced parole. In the EAD scenario, approvability is easy.
Yeah.
It's good now.
Yeah, but again, we've seen at certain times in the past what was once an clearly approvable case turns into a denial or essentially
Oh yeah, absolutely.
overnight.
Yes.
I mean, so to finish the thought, the practical answer is, what's the safest way to get back on H-1B? If there's any sort of gray, if you're in the gray and you want to do, the simplest way to do it, it's get an H-1B approval, get stamping, come back in. Bottom line, they should be able to do that. And that shouldn't interrupt your adjustment of status. That can continue. You're allowed to be on H-1B with a pending adjustment of status. If you want to get back on H-1B, there's the answer that's described in policy that basically, if you leave while in valid H-1B status, come back on advanced parole, and while you're still in valid H-1B status, file a timely extension. They should approve that. That's clear in policy. But outside of that, your clear answer is, file an H-1B with consular notification and leave the country and come back in with a valid H-1B visa.
And every case is on its own, so we need to look at the specifics to kind of pin it down 100%.
Yeah.
And Brian, my medical examination has expired.
Yeah.
Should I go ahead and submit another one?
Well, I think of myself sometimes like a medical doctor, Sam. It's informed.
Wow, I'm impressed.
I'm not that good.
I haven't even thought of myself as a medical doctor, and I've been.
But it's the concept of informed consent. Now, USCIS put out that policy a while back, saying we don't want you sending unsolicited medical exams, even though in the I-45 instructions it says yes, we can take them separately after the fact whenever you want. And fundamentally, I don't trust USCIS. I know they have a really great ability to lose things. They are, if something doesn't go where they expect, or they just can't figure something out, there's a great chance it would be lost. But if you can go into sending in a medical exam knowing that, well, they might lose it, and just accept that, it's not a bad time to send in a medical exam. If you just love your medical exam so much, you want to see it again at the time of an interview, or you just want it to make sure that it is gotten by the government, getting an RFE is not the end of the world. At least that's an RFE that that you can get in relatively quickly. Sam, do you think you're more likely though to get more issues on an RFE though if you have if they're asking for a medical exam, would they ask for might they ask for other things at the same time?
It depends, Brian. It depends. Yeah? It depends. So normally there was times when one RFE triggers a whole host of other things.
Yeah, while we're at it,
thing.
request.
Well, yeah. but not in the context of adjustment, because what's going on usually in the context of adjustment, honestly, the USCIS wants to approve these cases when they get them off their desk. And they are not going to, if they've approved everything, they're not going to say, oh, we got to, our people might as well ask him
Yeah.
about this. That I don't see that in an adjustment.
Well, I will give you that the straight medical RFE is still relatively common. I don't get a lot of them
Yeah.
where they say, well, and tell us about your work authorization as well. I mean,
Yeah.
that's the most common other adjustment RFE. Hey, tell us about your work. We want to make sure that you haven't been working without authorization, for example, since you filed your adjustment, but not really a terribly common issue at this point. That
So,
is for sure.
what do? You submit now, Brian? You didn't ask the question. You gave a
Yeah,
lot of good information.
if you
Yeah,
can,
I say no.
really, okay,
Well, I mean, if I have a number one, we don't submit medicals with adjustments because you don't have to, especially right now. If a priority date is 2024, I'm not going to submit a medical with a not 2024 case. Not necessarily India. Let's say current one country.
yeah,
I mean, we do. It depends on the case. I mean, like when we
yeah,
had the big rush, and knowing that things are going to retrogress, submitting an adjustment is, I mean, a medical with the adjustment sometimes may not make sense. That's
yeah.
number one. Number
Well,
two,
yeah,
if your medical expired and your priority date is 8 years backlogged, you're wasting money.
yeah.
I mean, if you're close, let's say you're within. I mean, when I say close, I would say within 2.5 years.
Yeah.
You know what I mean? Then
Yeah.
I would say go ahead. But
Yeah,
if
those
you're
20
if you're
those
too far out,
2014 the 2014 India priority dates, what's the point? Don't spend.
yeah,
Yeah, there's no requirement that you keep USCIS's file up to date for them. If they want to send you an RFE, and touch wood, I don't think many people with 2014 priority dates are getting RFEs from
yeah.
you. Occasional
Well,
interviews maybe.
they're buried
Yeah.
right now. They're
Yeah.
not going to go and harass people.
They're not looking
They're
for work.
basically
That's where.
buried under a pile of papers.
Yeah. Yeah.
I don't see submitting in medical for cases that are backlogged substantially. But if you're close, yes.
Oh yeah,
I
I've talked to
agree.
several people who say, Brian, my priority date's coming up in February. I know that my medical exams are expired, and I have another copy, a copy around here. That's
Yes.
the sort of thing where I
Yes.
always like when your priority date's coming current, Sam. Any excuse to send them a letter to remind them that your case is there, to make somebody have to pick up and look at your file, is something that I think is worth the time.
I agree.
Yeah.
All right, Brian. We may have entered a time where we have to answer questions. What do you think?
Well, we're always answering questions. We answered our own sort of, what are our common questions, but maybe some folks in our audience will have some more interesting, less common questions that'll leave us fighting each other and scratching our heads and
Yeah.
chins as well. So
Yes.
this is that time then that we're going to sort of take a look at the questions that people have submitted to us, along the stream here. And just remind everybody that when we're answering these questions, obviously we don't create an attorney-client relationship with you, because we have just a tiny bit of information that you've given us in a little text message here. Two, this is a public forum and there can't be sort of confidentiality there. And the bottom line is your case is so complex and as nuanced as you are personally. So why would I wouldn't say I could ever really kind of definitively answer any of these questions on here. So be sure to talk about your immigration matters with counsel of your choosing before you make a decision, because, well, it's your life, and I would want that for anybody.
Yes. All right. Sounds good. So good information. Let's take.
First question here.
Yes.
Yeah. From BR. Priority date March 12th, 2012. India. So EB2 straight, I believe that's a current date. I have H-1B stamping valid until July 2024. I also have EAD and AP, but not planning to use until the H-1B expires. I'm going to Mexico for vacation in February 24 and planning to use H-1B stamp at port of entry while coming back to the U.S. Do you see any issue in this? I haven't seen. So what I'm seeing is somebody here, Sam, and sorry, I'm putting it back on the screen. I have a valid H-1B stamping valid until July 2024. And I presume that comes with an H-1B I-797 from your current H-1B employer. And for me, Sam, that sounds like, generally speaking, what everybody needs to enter the United States for an H-1B visa. Would you agree?
Yes.
Yeah. I mean, my fundamental question for somebody who calls me and asks me this question, Sam, is, BR says, do you see any issues with this? And my answer is, well, do you? Is there something? What is worrying you about this? That's exactly what I would ask in a conversation. What is worrying you about this scenario? So I can either tell you have a problem or tell you not to worry about it. Honestly,
Yeah, because we don't know enough. I mean, we don't know enough to not have an issue or have an issue. We answer questions, and we're afraid to say no, we don't have an issue, and then there's a hidden
yeah,
problem in your case, and you can say, oh my goodness, I asked him on this forum, and they told me I have no issue. I'm stuck now in Mexico for the next 15 years, uh, and I want to attend those sessions from Mexico, and now I'm going to tell this Brian Berg who told me there are no issues.
yeah.
So we cannot say we don't have any issues with that. I mean, that's we can answer question, but
Yeah.
I cannot answer the
I mean,
question. Do I have any? I don't have any issue. No, I don't. But
my first, I mean, I
yeah,
will tell you my first, what's probably the first thing I learned that at least that's stuck in my memory as an immigration lawyer. It's who's guaranteed to enter the United States. It is U.S. citizens with their passport in hand. And anybody else, it is always, there's always a theoretical chance that,
yeah,
I've talked to plenty of people. Well, I can go on, but it's
yeah,
possible that you can have problems,
yeah,
Yeah.
yeah.
Yeah. So
Yeah.
let's see what we got here. So we have, it looks like not everything that we get, not everything that we get is complete, because we have some comments from Sky Limit here. Seem to be referring to a question about an EB5 regional center project, but I'm not seeing the first half. So Sky Limit, if you put that in there, we will try to get to that
It
in
may
the
have been
comments
cut
here.
off because of
If you put us to before we went live, or some just sort of technical
yeah,
glitch. Yeah.
exactly. Yeah, I see him putting it at minute number 2,
Yeah.
and typically, yeah.
Yeah. So I'm going to keep on moving on then. So, oh, an interesting question from Anshal. I'm on a non-cap H-1B.
Okay.
I-140 will get approved by September 2024. After I-140 approves, can I change to any employer, or will I need to go to the via the lottery for H-1B? I did not go get H-1B status via the lottery. So, Sam.
Well, that's a good question. So let's make sure people understand the question. So
Yeah.
there are two types of H-1Bs. One that is subject to the cap, and the other one that's not subject to the cap.
Yeah.
Those that are
Certainly.
not subject to the cap are research institutions,
Yeah.
colleges, etc.
Yeah.
Uh, certain research institutions and colleges. And the question is, I'm working for a company that is an
Exempt from the
exempt
cap. Yeah.
institution, and now I get an I-140. If I had an I-140 um, with that are cap subject, I can work beyond 6 years. Now, can I just jump and work for a cap subject employer because I have an approved I-140? And the answer lies in the regulations. The only thing, again, you got to read the regulations before you answer that question. And I don't have it in front of me to read it to answer the question, but I can comment on it. The only thing I can tell you about the I-140 language that I remember, that all what the I-140 language does, it remove the 6 year limit on lottery selected applicants.
Yeah.
From my recollection, it does not allow people who are not on an I-140, who've never been up, who, went through the lottery, to work
Yeah.
for a cap subject employer on H-1B. So I am skeptical,
Yeah.
but the devil is in the detail.
Part of being good at your job sometimes, Sam, is knowing what you don't know off the top of your head. And I
Yeah.
will fully admit that. But I agree with your basic analysis on that. I will tell the audience an interesting nuance about working for a cap exempt institution, and the concept of multiple H-1B employers. So, as our audience might know, it is possible to be approved to be on H-1B status and be approved to work for multiple H-1B employers at once. And a cool and kind of unique thing is that if you are on the non-cap H-1B, with working for a cap exempt organization, you can have a second employer on H-1B status, and that second employer can be a private cap subject institution, and they will allow you to do that as long as you are still working for the cap exempt institution. So that does create an opportunity for somebody like Anchal, for sure.
And that is allowed in the
Yes.
regulations.
Yeah.
Um,
It's not one that comes up a whole lot, obviously, but for example, if somebody's working again for a public institution, maybe there's some offer of some additional little bit of perhaps more lucrative work in the private sector. That's something that can definitely
Yeah.
be done there.
And I'm typing here trying to find the answer, but I don't think I'm going to find it quick enough
Yeah,
as we move on to the next question.
yeah. So let's, yeah, this is sort of a follow up from Anshul. If I have to go via the lottery, can I start working for any for-profit employer while they put me in the H-1B lottery? Can I work if my H-1B does not get picked and we have to try again next year? So being registered, generally speaking, being registered in the H-1B cap gives you no benefit, essentially. But again, I think I already answered your question. If you wanted to work part-time for a private employer that's trying to sponsor you in the H-1B cap this coming year, you would be able to start that, right now as soon as they're. To be clear, if you want to be working for multiple H-1B employers, you have to have multiple H-1B petitions filed with USCIS. You are only allowed to work for an additional employer while you're on H-1B status if that employer has a very special, simultaneous employment H-1B petition approved on your behalf.
So the only thing I can see in the regulations, Brian, I kind of looked it up quickly, is that it does talk about there's a section about H-1B cap exempt employers. If you work for an employer that is an exempt from an H-1B cap, such as universities, research institutions, or certain nonprofit organization, you may continue to work on H-1B beyond the 6-year limit.
With the approved. You're not subject to the limit, meaning?
Yeah, they're not subject to the limit beyond. So it does extend beyond 6 years, but it doesn't say you can work for a cap subject employer.
Yeah,
and then the word continue makes me suspicious that it does not extend to that.
Yeah, fundamentally, if there is somebody planning to sponsor, Anshul in the upcoming H-1B cap, which we got to start talking about in this forum soon, Sam, because the registration will be opening in March, and there's going to be potentially going to be some changes to it. That's the sort of thing that your employer's immigration council, it's the sort of thing that Sam and I are capable of looking up, but it's just perhaps not the best time for us to give our full attention to that relatively small little bit of research project.
Yes.
Yeah.
All right, so let's jump in here to the next.
Yeah. So this is one from HF, and the answer is, hi, can a father be an accredited representative for his minor child and file G28? So
why would you want to be an accredited representative for your child? You can sign for your child as a guardian.
Yes.
So I don't know why he's talking about
maybe I'll take a step back here and sort of explain it a different way. So, as I think I kind of interpret the question, Sam, the same way you do, that somebody is filing an application on behalf of their child and wants to file a G28, so the government sends them correspondence about it, right? That's how I'm interpreting this. And my answer to that would be, well, an accredited representative is a specific thing, that a requirement that you have to meet. I've only researched once or twice. It's been a couple years since how to become an accredited representative, but you cannot sign off on that G28 as an accredited representative without actually being accredited as a representative. It's not just a box you check. There's more to it than that. And I think I agree with Sam's answer. If you are trying to basically sign off on a form on behalf of your child, who's a minor under the age of 14, is immigration, they will expect children over the age of 14 to actually sign their forms, as I recall. Look that up on the government website. Talk to your attorney about that.
As a guardian, you can sign on behalf of your child.
Yeah.
We do that all the time if we have to. An accredited representative is an accreditation through the agency to allow you to become an accredited representative. I mean, there's a list of people like priests. They can be. Law students can be. And then others.
I think the BIA can certify you to
the Board of Immigration Appeals and the Department of Labor has their own. Department of Justice, I believe, they have their own criteria to make you an accredited representative.
Yeah. So bottom line is.
And why would you want? You don't need a G28, by the way, for your son. You
I
sign
guess
for your son.
Well, it's a general, maybe it's a general thing we've never really mentioned here. I was talking to somebody about this today in sort of a consult scenario. I had somebody who was just a service fill out immigration forms, for me to help me on my immigration case. And generally, the rules is that's probably something that would be considered unauthorized practice of law. Generally speaking, the only in immigration world, only attorneys and accredited representatives are allowed to really do immigration filings on behalf of other people.
Right. And accredited representative, I can tell you, I mean, the 99.99% majority of them really are not even competent. Maybe they're accredited to file most of the cases.
Yeah.
Who's going to file a motion to reconsider or a motion, a notice of intent to deny, response to a notice of intent to deny, or these kind of complex labor certification? Very difficult for non-attorneys to do that kind of work.
Sam, I scrolled down a bit. I think there's a follow-up from HF here that maybe will sort of explain. I am filing EAD/AP renewal for my family by myself. Daughter is 15. Do I need to file G28 for her as an accredited representative, or can she? Yeah. So I think we've already answered the question.
Yeah.
She is 15 years of age. They allow she can sign those forms on her own on behalf, and should read them on her own behalf, because there's an attestation at the end that it's going to ask her, whether or not she's read these things. She might as well. It's going to be a fun learning experience for her. Well, I don't know if a 15-year-old would find that fun, but maybe just a little bit interesting.
Yeah.
Yeah. So a question from Harsha here. My spouse used AOS EAD, and we have H1/H4 extension in a few months. Could I request for her H4 extension? Well, Sam, what's your take?
So your spouse filed H1 before a few months. Sure, absolutely. Why not?
Well, I will give you an alternative take. So this kind of answers that question. It's how do I get back in status, back in H1B status. It sort of dovetails off of that.
I think that's the question is being asked is, can I get her back on H4? So you can file for an H4 extension. That H4 extension is not going to be, if she used, I see.
Hey, Sam, how would they know? How would they know she used the AOS?
That's not relevant, right?
Yeah, well, yeah.
But the problem is that they approved it, and then you think you're back on H4, but in fact you're not back on H4.
That's a very good point right there. This goes to that classic question. Well, how would the government know? They don't know. But if you tell me that, if somebody calls me up on the phone and says, "Hey, my spouse used the adjustment of status EAD," well, technically, you're not you're outside the four corners of the H4 status. If you wanted to work while you're on H4 status, you should have gotten an H4 EAD.
I'm wondering whether the form has the question.
Have you ever worked in the United States? They do, yes.
Yeah, so that might tip you to maybe that might create an RFE and potential denial. Of that petition.
On that, so this, I don't know how they'd handle that, but on towards the end of the long list of there's a page on form I-539, the H4 extension, the form used for H4 extensions, and asked, I believe it's, have you worked inside the United States since your last admission? And your wife's answer would be yes, and they would ask, okay, well, who do you work for? What's your weekly pay, and how was it authorized? And the answer would be, of course, I work for so and so. I have a weekly salary of this pursuant to a USCIS EAD. If you're answering that question, right? And again, this falls in that question: would they catch on to that issue? Would they approve it? Maybe they would, but can you count on it? And that's the fundamental question, Sam. And my answer is no, not if your back's to the wall, essentially.
Yeah.
Yeah.
I agree, Brian. I mean, that's part of the issue, that the laws are not.
It's the gray. The gray.
Yeah, not very clear for people. And people file for H4, they think they're back on H4, and they're not.
Yeah. Well, it's the common scenario.
It's not the end of the world yet.
Yeah.
It's not the end of the world yet, because let's assume they're not on H4. They think they're on H4. There's no consequence.
If you still have a pending adjustment, sure.
Yeah.
I mean, I would ask, well, I'm going to maybe answer the question of how Harsha's wife might theoretically get back in H4 and be able to extend. Well, if you have a valid H1B right now, Harsha, I presume I'm going to say maybe you and your family have valid H1B and H4 visas. And if you do, if your wife were to leave the United States and come back in using her H4 visa, she would be back in H4 status, and then would be able, presuming she's not using her EAD again, she would then, in my based upon what I've heard, would be able to extend her H4 status in the United States. It's
I
about
agree.
getting on back in clean, clear, good H4 status once again, in my book. Yeah.
I agree. Good
Yeah.
analysis.
Well, Sky Limit has popped up again, but with
Part one, part two. I like
yes,
it.
yes.
So let me read that one, Brian. You've been working hard. I'm gonna give you a break.
Whew.
Yes. So part one. Hi Sam, because he said hi Sam, so I want to take that one. And Brian. Last time I wasn't clear about my question. Currently on H1B, valid visa and I-94 for 3 years. Nice. Also have an EB5 petition pending. Have a CO9 EAD based on that EB5 project. Part two, Brian.
Part two.
Part two, EB5 is a regional center project. If I keep working on H1B but open another business using CO9 EAD, which status will I be in? Is it even possible? Sky the limit, I think, and I put that in the middle because I like that instead of sky limit. Sky is the limit. I think you were clear last time, and I think you're clear now.
Yeah.
If you work on that EAD, the CO9 EAD, you are no longer on H1B. It's that simple. And if you do anything that is an employment outside the H1B, then you've lost that H1B.
Yeah.
You can reestablish it by leaving and re-entering potentially, but they are incompatible like oil and water, and you have to choose between them.
Yeah.
Brian, do you want to add anything to it?
No, I'm going to be unusual for myself and just go, yep, I agree.
Yeah.
Yeah.
Yeah, you can stay on that EAD and not worry about it if you want. But yes, if you're interested in keeping that H1B,
yeah, a C9 EAD is the standard, the same adjustment EAD that everybody else gets, and that is, in theory, yes, you can open a business on the side if you're using that, but yeah, you're just not. You're not on H1B status anymore.
Yep.
People come and ask us, the answer to this question is always the same. People ask somebody, I did a consultation with somebody last week, was asking, hey, can I do X on the side while I'm on H1B status? No, you definitely, cannot. And I said, well, if you have a pending green card EAD, well, you can use that and do whatever work you're doing right now, plus more on the side, but you just won't be on H1B status anymore, as I read it. Yeah. So, another question here from Soba Lila.
I'm a green card EAD.
Mm-hmm.
Okay. Priority date December of 2013. If we lose the job today, how soon would I need to get a new job by submitting an I-45 supplement J from the new job? So again, I know the priority date because I've been staring at the visa bulletin today all day, but I was looking at a different category. But I think it's 2012 for EB2 and EB3. But let's look at that. All right. So,
well,
I'm assuming India.
Yeah, you're gonna answer questions related to the priority date. I myself, Sam, have queued up that USCIS FAQ in the subject of, what happens if you're unemployed during the pending adjustment of status. So I'm ready to.
Why don't you jump on it right now?
Well, so for Sobalila, there is a recent USCIS FAQ, which is kind of, in my book, pretty well on point for your question. And I'm going to, Sam, I realize we have the benefit of this restream chat here. Apparently, I can send messages to people, and I'm going to send everybody a link. Give it a try, see if it works, to the employment-based adjustment of status FAQs for anybody who hasn't seen them before. But on that webpage, you will find this response. A non-citizen with a pending adjustment of status application based on a prospective job offer may be unemployed while their adjustment of status application is pending, and depending on the facts involved, may remain eligible for adjustment of status. However, a period of employment in an occupational classification different from the prospective job, or a period of unemployment, may affect a non-citizen's current immigration status and could raise doubts about the continued validity of the job offer and or the non-citizen's intention to accept the offered position after adjustment. So
So sounds to me like speaking from both sides of your mouth,
I would agree.
from this side and that side at the same time. But there is a distinction. But go ahead, Brian, explain it. I mean, since you have it in front of you, it looks like to me they're making a distinction between, gaps in employment that is reasonable gaps of employment that's acceptable.
Yeah.
On the other hand, while it's acceptable, be prepared to prove that there's a bona fide job offer by that employer, and you have to explain why there was a gap of employment and there was a job offer at the same time,
Yeah, I mean,
because they're inconsistent.
yeah, I don't see how you shouldn't be able to say, oh, I've lost my job for a while and then I got a new job and supplement J is there. And I guess, I mean, Sam, how do you think they can possibly deny a case if you have, say, don't have a job for a year, but the time they're ready to approve your green card, you have a supplement J and a job offer in hand? Do you really think they could do that?
They have not done that so far, Brian.
Yeah.
And I can tell you one thing: if there is a denial of an adjustment of status, so this is really interesting. So, an adjustment of status has a discretionary part and a non-discretionary part, and this one is the non-discretionary, in my opinion,
Yeah.
part of the adjustment.
Yeah.
So I can see this thing going to court very quickly.
That's exactly where my brain was at. That's what
But
I'd love
because
to
there's
take forward.
just a decade of waiting, and then you work 9.5 years and you didn't work for
Yeah.
6 months, and all of a sudden you don't have a job. How unreasonable that can be.
Yeah, I think somewhere in my core complaint would be so and so is waiting, 10 years for a green card due to the silly government backlog, and essentially the government waited until a massive economic stagnation to kill off their green card case, and are denying this one without really good policy or law to support it. I'm saying I'd call baloney on that. Yeah.
Well, I mean, yeah, I would too, but there's a couple things here that we need to be aware of. I mean, number one, the mood of the country at the time. For example, you take a case like this to court during high unemployment rate, you may get a decision from that same court than if you got when there's low unemployment rate and high prosperity.
Yeah.
So these cases, and then also, by the way, you can get a completely one decision from a case of somebody who may look bad, done a couple things bad in the
Yeah.
case, and the facts are not very favorable. So this can go either way. However, I can tell you today, so we don't confuse our listeners. Today, there has never been a case that I'm aware of that's denied based on a period of unemployment, and there was a bona fide job offer at the time of the adjustment. Not a single one in 30 years. I haven't seen it. So I'm going to say not a concern, but you never know in the future.
Yeah, yeah. I think no matter what, my answer would be if you have a pending employment-based green card and you find yourself laid off, get to a job search immediately, because
Well, you just gotta try the self-employment. I
that's
mean,
an option too.
you
Yeah,
just cannot just sit down at home and watch TV every day.
yeah,
You need to have. I mean, if you are in this pool of people who are uh, IT professionals or engineers or whatever, and you are in the 2012 uh, priority date, 2015 priority date, 2017 priority date, you're making good money. Okay, trust me. Expect changes to occur in during your career,
that's true.
and a change of job and a loss of job at a certain point. Now, I'm hoping it never happens, but it will happen, and sometimes it
Yeah.
happens quicker than you think. So here's what you need to do. Number one, you need to save some money. Okay, you need to save some money. You need to put some money aside. A lot of you guys do that, and you're very smart at that. Second thing is, the moment I lose my job, I go to a self-employment AC-21, because you can get out of a self-employment
Yeah.
AC-21 and get back to employment, but you can fill that gap
Yeah.
during taking a odd job here and there, and pay yourself a salary.
Yeah.
You can contact a payroll company that can set you up with a payroll right away. You contact your attorney or an attorney you trust and say, hey, what shall I do here to protect myself? But you just cannot sit down, wake up in the morning, have coffee, and watch TV, and just for 8 months,
Do,
and then later deal with it.
it's
You're not
important to
taking
do
care.
everything you can to protect yourself.
Yes, yes.
Speaking of changed circumstances, this is probably, I'll apologize to the audience, Sam. This is probably only interesting for you and me, but I understand there's a case going before the Supreme Court sooner or later about Chevron deference and basically them trying to get rid of deference to the agency. Speaking, that's something that could totally change, a court case like that in the future, where really, right now a court might be required to defer to an agency's interpretation of whatever its rules are, but maybe it'll be make court cases more common in the future if that change happens.
I
Uh,
will not comment, because once I do that, you and I will go for half an hour on
yeah.
this.
So,
So
but
we will.
Chevron deference on the
Yeah.
table. Wow, it's going to throw out a bunch of stuff I learned in law school. I guess potentially anyway.
Only, yeah, potentially, yeah,
Yeah. Yeah.
exactly,
Yeah.
exactly, yeah.
Yeah.
So yeah. Um, all right.
Anyhow,
So next one, Brian,
yeah.
go ahead.
From Vivek, can a new Republican president scrape EAD/AP for EB folks if party days 2013, 2014 Indian green card applicants, as we know how hard they made it to get H4 EADs in the past? Well,
So number one, there's no such thing as new president as it appears on the horizon. So either president one or president two.
same old president. There's no new. You're very yeah. It's an old. Yeah.
Yeah, it's going to be one of those two guys, right?
Yeah. Yeah.
But can a president unfavorable to immigration does something like this? Number. Remember, employment authorization document. It's more difficult to do for adjustment, because that's one of the it's in the regulations. Now, can they rewrite the regulations and do it? It'll be difficult to do that. Not impossible, but difficult.
Yeah.
The advanced parole approval is discretionary and based
Yeah.
on a humanitarian
Yeah.
basis.
Generally speaking, they don't require a reason for an advanced parole right now. They could start requiring reasons for advanced
They can make it
paroles.
more difficult for advanced parole,
Yeah. Yeah.
potentially. Where I see what a non-favorable president would do is something typically not change the law, but would take a year and a half to approve an EAD. Of course, I'm not saying that's going to happen whatsoever, but they tend to affect the law without changing the law.
Yeah.
It's easier to do it that way than to go about changing the law. So those are the kind of things that we don't control, and then we end up having to go to court and sue them for delays, etc. But that's how I see things changing: is delays. I mean, the EAD fiasco started in the prior president's era, when, if I remember correctly, and don't quote me on that, I believe the vendors were not paid. They were issuing printing the EAD cards, and the money was diverted for other tasks, enforcement tasks.
I do remember a time when basically they had a 3 or 4 month backlog on the printing of them, which is a huge
And the green
issue.
card, the printing of the
Yeah.
green card
Yeah.
got
Yeah.
delayed.
Yeah. I'd
So
forgotten about that. Yeah.
silly things like that can affect your life without having to change the law.
Yeah.
Unfortunately. So we hope that's not going to happen. And the new president, or the old president, whatever you want to call it, has bigger fish to fry than messing around with our EADs. But we'll see, I guess.
Yeah. Anything in the realm of employment-based green cards is just such a not. It's. I mean, like I said, we saw an article in the Columbus Dispatch a couple of months about the waits for employment-based green cards, but in the national dialogue, it's people shouting about the border right now. It's really
The border is a crisis. There's no
Yeah.
question about that.
From Emily, USCIS in their new fee prices, they want to charge different fees for online and paper files, which EAD and AP is one application with these differences reflected, based upon based upon the option you select. And it's sort of a question that comes with this. It's, do you gentlemen think EAD, AP, and I45 will have online filing? And my answer is going to be yes.
They want to push everything online. They're not ready for it, and they want to push people in that direction. We have low confidence in it, but I hope they do a better job, in which we will be able to track things better.
Yeah.
The question for us as attorneys is obviously, is their system sophisticated enough to manage it properly,
Yeah.
or are they going to throw something stupid online that we're going to have to suffer all of us through? So we'll
Yeah.
see what happens.
Yeah, to complete my answer, it's yes, eventually, but not when they're ready. Before they're ready is when they will launch it. That's for sure. And we will be you and I, Sam, will be the ones who are pained by it because we're the attorneys that really have to
Yeah,
deal with this,
yeah.
this sort of thing. Uh, what do we have here from Sarab? Um, I have a pending 485 in EB3 with employer A. I switched to employer B in 2023. My priority date is July 2014. Will I need to restart the perm process with employer B to get my green card?
So uh, you definitely need to talk to an attorney to help you with that. Um, if your I-140 and I-485 is being approved and 180 days have passed since the filing of the 485, you more than likely will not need to file a new green card application with this new employer. You just need to do supplement J.
Yeah, a
Um,
proper portability
yeah,
application. Yeah,
but because it is your absolute future in doing things properly, a quick consultation with a smart lawyer uh, to give you the peace of mind necessary. And you also need to have a relationship with an attorney you trust, because I don't know what your priority date here, 2014. You're into this for a little bit of time, and just having a relationship with a lawyer, I think, will help you in time of need when there is a crisis.
yeah,
But on the face of it, yes,
yeah,
you should be able to do it.
yeah. So, Sam, well, I'll let you read this one, I suppose.
I am a U.S. citizen, and my wife is an F1 student. Would it be a good idea to get married in the U.S.? Did he say my wife and then get married? So my future wife, I don't know. Would it be a good idea to get married in the U.S. or overseas? Will getting married overseas and having a foreign marriage license be a problem? So I see here things a little bit inconsistent when you call her your wife and then talk about getting married.
Yeah.
So I that confuses me a little bit. But I'm going to answer the question asked only. A foreign marriage document is normally recognized in the U.S., subject to very little exceptions. There are few scenarios in which it can be an issue. And I'll mention just two of them to kind of highlight that, these are not normal scenarios, but just to highlight. So, for example, proxy marriage is not recognized in the U.S. So a marriage in which you and your spouse are not physically present in one location is not one that's recognized. You want to add to it, Brian?
I believe Utah actually the state of Utah has a law by which people can get married online, and it's a controversial
That's
topic
okay.
as to
That's
whether or not.
okay, but
Yeah,
still, if I guess if you're living in Utah, you may survive
yeah,
that law. If you're not living in Utah, is not an issue. But in general, USCIS has been clear that on proxy
yes,
marriage.
I fully agree with
Yeah.
that. Yeah,
The second one that's controversial, and this is just listing two of them, is first cousin marriages. There are several states that recognize first cousin marriages. Many other states don't recognize first cousin marriages. And I have encountered this issue also in employment based immigration. When you're
yeah,
filing a derivative petition for your spouse, if you're living in a state in which they don't recognize first cousin marriage. Now, most states do recognize it, some states don't.
yeah,
But I know half the world recognize it, and most states recognize it, but not every state.
yeah.
So if you are in a state in which first cousin marriage is not recognized and foreign first cousin marriage is not recognized, USCIS is not going to approve that derivative petition. You have to be living in a state in which a foreign marriage is recognized. Now, you're not asking me a question about that. You're not telling me your wife is your first cousin, and you're not telling me you had a proxy marriage. But I'm just telling you, you're asking me, is a foreign marriage license a problem? Most of the time, it's not a problem, subject to few exceptions.
Yeah, we do marriage-based green card petitions all the time with foreign marriage
Yes,
certificates.
and
Somebody
they
goes overseas, marries their spouse, comes back to the U.S., files on their behalf.
99% of them are good,
Yeah.
good marriages. Yes.
So the other question there is, will it be a good idea to get married in the U.S. or overseas? And noting that this individual has an F1 student visa, I think you could potentially have a problem with getting married overseas. Essentially,
Well, that's a debate. It's 7 o'clock, and you just opened up a big, big can of worm, Brian. Um, um,
yeah,
yeah. So
sure,
yeah, so I would say consult with an attorney for sure. There's so much to this
yeah,
that you need to learn. I guess the best advice I can give you is you got to talk to a lawyer
I would
because
agree.
there's
Yeah,
so much to this that is so fact driven and
yeah,
detail driven that can make the difference between a happy first year of marriage or a miserable first year of marriage. So you need to make sure that you talk to a lawyer. I cannot emphasize more in your case.
yeah. I'd say the bottom line for me, it sounds like there's definitely a path to a green card for somebody like that, and that's always a good thing, right?
If it's done right.
That's true. Yes. Yeah.
Brian, it's 7:02.
Yes, sir.
Uh, let's take one more because I know I have to be somewhere else soon.
Yes, and well, Sam, I think the last question we have here is certainly a doozy of a question, for sure.
All right. Hello,
Uh,
guys. I have a question for you guys. I have someone in the United States for 20 years but no status. What do you guys recommend for you to get status in the United States? Well, well,
Depends.
yeah. Wow. Wow. Do you guys have another 45 minutes? Because there's so much to that one and not enough facts to answer. There is so much to this. So you've eliminated a lot of the option because if you said for 25 years, that would have added more options because back in the year 2000 and before there were other laws that sunsetted in the year
Yeah,
2000 that also would have may have provided solutions. But 20 years, but 25 years will be a different answer. That gives you an idea. So I would say you got to talk to a lawyer
yeah,
on that one. I won't even touch that one.
yeah. Depending
Uh,
upon the facts of your case, the answers could range from, oh yes, definitely, there's a solution there, or no. It's it was really highly fact sensitive. That's an honestly like an hour long conversation with an attorney to get a background out of you. And
here's one advice I would give this gentleman.
yeah,
Um, don't call an attorney who is going to give you only 10 minutes of your time, of his time on a free consultation. This is not the kind of case. This is where you want an attorney to say, I want you to give me 45 minutes of your time, whatever that costs. I want to pay fair fee for it, pay them whatever attorney of your choice. I don't, somebody competent and tell them that I want you to kind of go through my case and tell me if there's a reason. Because honestly, unless you do that, you're going to have a quick answer, which is like too
yeah.
complicated to answer in 10 minutes.
I imagine you're right, Sam. I imagine a half hour is about the time you need to get the story
Yeah.
out of this
Yeah.
individual. Yeah.
And with that, Brian, we come to an end of our January 29th, 2024
I'll take your word for it.
presentation.
Yeah.
And looks like February 2024 will begin next week, Monday at
I
6
believe
o'clock.
it. Yeah.
And
Well,
we
actually,
will,
Sam, February will begin actually on Thursday. To be clear, Thursday probably about 12 midnight,
yeah,
12:01.
yeah.
But we'll be
Fe-
back on February
yeah.
5th. I agree with that.
So February 5th, I'm flying back, Brian. I'll be here early afternoon joining you for this session.
Okay. All right. Well, we'll
It's
see.
my daughter's birthday, and I'm flying to be with her.
All right. Well, I will. We'll see you then, Sam. If you don't make it back, we can always do it. Remotely as well. It's been a while since we've had one of those. So, well,
Unless I'm stranded in an airport somewhere, in which case we'll give it a shot. What the heck?
there you go. Airport
Yep,
Wi-Fi. Test out its strength. All right.
exactly.
Well, thanks so much, Sam, and I will see you later, and I'll
Yep.
see you all later. Thank you.
Thank you.